guys, it's Mo from Mo in the Deep End, and we are going to do kind of short little clippy things. This one might be a little longer, but about some of the stuff that I'm finding in this document dump. And it kind of relates to an article I was sent earlier. And we are going to go through that. And then I will bring it back to the documents that I went over. So, this is about ballistics information or ballistics rulings and how credible are they? Now, I know we can already hear our resident Swede yelling from that far off land that may or may not exist. Not even sure Europe exists anymore. But we will take what these it's the Maryland Supreme Court, so it's not the Indiana Supreme Court, and I am fairly sure that out of state Supreme Courts don't work, but I'm not a lawyer. So let's see what the argument against it is, though. So let me pull that up. I'm going to be all professional ish. It has to be an ish. There will be no fully professional ever. I am very sorry to disappoint. All right. So Maryland Supreme Court ruling makes it harder to prove what bullets or what guns bullets came from. Awesome. I'm gonna learn how to read. I read for a living now. This is a terrible idea. When you only have 84,000 tabs open, it is just an awesome day. Let's move this and move this. Annapolis, Maryland Supreme Court issued a ruling Tuesday that could have far reaching implication in criminal trials involving a gun. In a 4-3 decision, the state's top court said ballistic experts could no longer testify whether bullets or fragments recovered from a crime scene were fired from a particular gun. Going forward, the court ruled firearms examiners should only analyze if bullets are consistent or inconsistent with those discharged from a certain firearm. In a 59-page opinion, the majority cited and compared multiple studies and testimony from witnesses. One study found ballistic tests came back with different results between 20 and 35% of the time when examined twice. Another study found bullets fired from certain guns were correctly examined more often than other models. The court's ruling stems from a 2012 Prince George's County case in which Kobina E. Arbakwa was accused of murdering his roommates, Ivan Aguirre Herrera. Y'all, I am trying. I mean, no offense. Y'all. Prosecutors used testimony from a police firearms expert to link bullets found at the crime scene to Abagwa's gun. That was enough to secure a murder conviction from a jury in 2018. Abagwa appealed and is granted a new hearing, only to be found guilty again. Now Abagwa will be tried a third time. They just had to use it like 18 daggone times, knowing some hillbilly from Indiana is going to try to read this crap. Y'all. Investigators have long used forensic firearms evidence to help make their case in court, usually by analyzing and comparing unique patterns or markings on the bullets fired by a specific gun. It is unclear what impact the ruling could have on those who have already been convicted with the help of ballistics evidence. So, this is something that I believe true and, in fact, real lawyers did go over. I believe Branca and Kurt from Uncivil Law probably did a much more lawyerly, academic ish, reading and reenactment of these things. Y'all are coming here for my lipstick. Y'all know it. All right, let's get this up. So this is the motion in limine that the defense has filed. So we will be going over that. This is in the Richard Allen case or the Delphi case, depending on how you're doing it. One of the main pieces of evidence that has been stated on both the probable cause affidavit, but even in trying to file for a warrant was um, and the warrant will be coming into play soon because they want to quash everything gotten in that warrant because apparently they did some allegedly, unconstitutional things, but let's see what they are saying about this. Motion in limine regarding ballistics. The defendant, Richard M. Allen, by counsel Bradley A. Rozzi, respectfully moves the court as follows. 1. Defendant is charged in 2 separate counts of felony murder pursuant to Indiana court ruling numbers. Oh, sorry. 2. There is no trial date set as of the filing of this motion. This was filed in, I'm getting old, 6/13/2022. So this is a fairly recent filing. And they didn't, I believe, come to a date in early January of next year until, I believe, just a couple weeks ago, or maybe a week ago. 3. Counsel for defendant Allen, upon information and belief, has reasonable cause to believe the prosecution intends to introduce as evidence the following: A. Testimony from laboratory assistant Melissa O. and or her agent supporting the findings referenced in Indiana State Police Laboratory Division Certificate of Analysis attached and hereto as Exhibit A. So they have the receipts of the analysis that they got from the things. I tried to read it. It was like Latin and Chinese had a baby and put numbers in there. So I tried, y'all. B, testimony from laboratory assistant Melissa O. and or her agent supporting the findings referenced in Indiana State Laboratory Division Certificate of Analysis, hereby hereto ad- as Exhibit B. C, bench notes and other literature and information in support of conclusions generated in the attached exhibits A and B. 4, there this evidence is inadmissible for the following reasons. A, the items analyzed and the conclusions drawn by the Indiana State Police Laboratory Division are irrelevant and therefore inadmissible under Rule 401 and 402 of the Indiana Rules of Evidence. B, the probative value of said evidence is substantially outweighed by the danger of unfair prejudice. Furthermore, admission of information will confuse and mislead the jury, all of which is in violation of Rule 403 of the Indiana Rules of Evidence. C, testimony regarding the analysis and conclusions referenced in Exhibits A and B runs afoul of Rule 702 of the Indiana Rules of Evidence in that the examiner is not qualified to draw the referenced conclusions, and in addition, the examiner's testimony does not rest upon reliable scientific principles. 5. Such evidence is not necessary for a full and fair determination of the facts of the instant case. Wherefore, the defendant, by counsel, respectfully requests that this motion in limine be granted, and requests the court order the state of Indiana, through its prosecutors and witnesses, not mentioned, refer to, interrogate concerning, or attempt to convey to the jury in any manner, directly or indirectly, the existence of any analysis conducted with regards to items referenced in the exhibits A and B, as well as any conclusions drawn therefore therefrom without first obtaining permission from the court outside the presence of the jury. Further instruct the state of Indiana and its witnesses to not make any references to the fact that this motion has been filed and granted, and warn and caution each and every one of their witnesses to strictly follow these same instructions, and order all relief just and proper in the premises. So let me pull up those while we are waiting. I have all my handy dandy notepad papers with all the page numbers. So I just need to find them. Because they did this wonderful document dump and then they just left everything in like a mismatch of craziness. Now, I do believe that there is a motion to squash this, or it might not have been filed yet. The state seems to be fairly quick at filing like the hell nah response. Okay, guys, I will have to find it and post it on maybe my community page because there's only 873 things. Yeah, this is not a channel of just watching me read my notes and then not realize what I'm doing with it because I highlighted it all. It is not that. Well, so that is what is going on, at least as far as ballistics go. As we know, or if you've followed this, I will try to link all of my other videos about Delphi into this, a playlist of sorts if I can do it. Y'all, this is still a duct tape prayer and holy water and a lot of curse words stream. So it is dodgy at best if I'm going to figure out how to do the playlist, but I'm going to try. And hopefully we can get that done. And then you guys can kind of at your leisure just watch videos. I'll be putting this one out today and then possibly another one about the list of inventory and sort of the motions filed by the defense in regards to the search warrant because there is supposedly some unconstitutional shenanigans going on with how they got the warrant and everything else, which I am here for. I want to know all the things, so when I continue to have my belief that if he did it, let's actually convict him with, using science and all the stuff that we're supposed to, then that would be great. I would love to, at the end of this say, "Yeah, of course, he totally did it. I feel very safe in my ability to, deal with that." But I don't right now. With the documents that I've currently read, it doesn't look like that. But I did wanna give you guys kind of an update of where things are. The, defense filed just a slurry of motions and things at this last hearing, and then they dumped all the documents, so expect a lot more of these short little kind of this is just a little nugget of info that you can take and go and feel a little smarter, but, you know, don't have to listen to the kids listen to Baby Shark for 5 seconds. Well, I hope y'all have a great day. Come back, tell your friends, family, spread the word of Mo, whether you're a motivator or a mofo. Everyone's welcome here. We like you. We like you a lot. We'll see you again next time.